He was setting this up to kill me, Judge.
I got a gun, and I'm going to go shoot him right now.
In the state's view, the appropriate charge for spitting in that situation is a charge of disorderly conduct.
Right now! You spit in my face!
If someone spat in your face in your mouth, brandished a gun, and they were going to shoot you, would you believe disorderly conduct was a just charge? Justice must mean the same thing for everyone, regardless of their title or uniform.
I'm not here to defend Mr. Fahey. Mr. Fahey had a firearm, encountered the defendant, and never acted on those words. Mr. Fahey did indicate he had received threats, not from Mr. Reyes, okay, to be sure, and neither have I.
You threatened to kill me! You threatened to kill me!
He threatened to kill me. He made multiple false statements to law enforcement. This is a cover-up. This is a conspiracy. He's charging me with criminal trespassing for leaving in 2 seconds. Breach of the peace when it wasn't a public place. So I don't want to talk about elements of crimes and what fits and what doesn't, because the elements I'm charged with don't fit.
Mr. Reyes and I do agree on one thing. I wish Mr. Fahey had stayed in the house that day.
Get out of my way.
Mr. Reyes, I appreciate your candor and your eloquence. The act of spitting on an individual is a vile and degrading.
Thank you, Your Honor. This is down for an AR application by Mr. Fahey to the court. I will let, I suspect the best way to proceed about this is to allow Attorney Ment to address the court first. I do, and then allow Mr. Reyes, the victim in this matter, to address the court. And then I do have a few comments about the charges, since there's been much talk and many emails to me about the charges, before Your Honor rules on that.
Good morning, Your Honor. The court does have our application for AR in front of it. The statute was created exactly for situations like this. The statute, I believe, has been in place for more than 60 years. And it is in place in cases where there has been a first-time offense by someone who the court can find is not likely to reoffend in the future. And that's exactly what you have today. You have a disorderly conduct charge, a C misdemeanor by someone who has not offended in the past and clearly has no reason to reoffend in the future. And I believe that this diversionary program, its pretrial application for accelerated rehabilitation, is quite appropriate in these circumstances. I understand there'll be an objection, and perhaps I can be heard again after that.
And does the victim, Mr. Reyes, wish to be around?
Yes, sir.
Good, Mr. Paul.
Thank you, Your Honor.
Yeah, that's fine.
And Mr. Reyes, if you would stand at the counsel table. Mr. Reyes, there's a request to have you videos for all you object to that.
I do not object, Judge.
Right. You just identify yourself.
Sean Paul Reyes. Thank you, Judge. Thank you for allowing me to be heard today, Judge. I stand before this court not only as the victim of the defendant, former Sergeant Brian Fahey, but as a citizen who still believes in the rule of law that must be applied equally to every person, regardless of the badge that they wear. My first encounter with the defendant took place in June of 2021 at the Connecticut State Police headquarters. The defendant violently grabbed my camera from my hands, threw it to the ground, grabbed me by my shirt, while jabbing his finger into my chest. He later claimed, falsely claimed, that he thought my camera was a firearm. No accountability followed, neither from Internal Affairs nor the state's attorney's office. 2 years later, in July of 2023, it happened again. The same sergeant, Defendant Brian Fahey, confronted me outside of the barracks, preventing me from entering in the public building, slammed the door on my leg repeatedly, seized my camera from me again, and threatened to arrest me. Again, there was no accountability whatsoever. That continued lack of accountability emboldened him and ultimately led to the incident that brings us here today. During that incident, my cameraman and I went to the defendant's residence to ask about allegations of fraudulent overtime. Apparently, the defendant works a desk job and is receiving $85,000 a year in overtime, more according to him. The defendant answered the door and told me to leave. I began to leave immediately. Video evidence shows that I left within 2.4 seconds and never stopped. The defendant then went inside called 911 and said, quote, "I am going to shoot him right now," end quote. Those are his words that were conveniently left out of the state police's internal affairs report, even though there was much editorializing and excuses being made, as per usual. His own wife can be heard on the 911 audio begging the defendant not to go outside. He didn't care. The evidence and video footage clearly shows that as my cameraman and I were complying with his order to leave, the defendant advanced towards us with a firearm in his hand, repeatedly bumped into me, and then committed one of the most vile, degrading acts imaginable. He spat directly into my face and inside of my mouth. I will never forget the feeling of that vile spit in my mouth. It was disgusting and degrading. At that moment, I knew exactly what the defendant was trying to do: provoke a reaction so that he could carry out the threat he had just made to shoot me. I am alive today only because I refused to respond to that provocation, and because my cameraman was there. When the Groton Police Department arrived, instead of arresting the aggressor, a state police sergeant, they arrested me and my cameraman for the absurd charge of felony voyeurism, a charge that's since been dismissed. An officer even told me that spitting in someone's face is only a felony crime, if the victim is a police officer. All laws should protect everyone equally. Only after public backlash and being transferred to this district was the defendant, after a month, the defendant was arrested. No mugshot taken, Judge. No perp walk, just, I would assume, walked in, walked out. That's not what happened to me. And even then, it was only charged with disorderly conduct. Judge, I fully understand that it is not within your authority to bring charges. That power belongs to the state's attorney. But it is within your authority and your obligation to decide whether accelerated rehabilitation should be granted. Under Connecticut General Statute 54-56E, accelerated rehabilitation is a privilege. It is not a right. It may be granted only if the offense is not serious in nature, the defendant is unlikely to offend again, and granting it would not endanger the public interest. This case fails on all three counts. The conduct here was serious, Judge, and violent. Brandishing a firearm, physical aggression, spitting, explicit death threats. The defendant has showed a continuing pattern of aggression and abuse of authority. And granting him this privilege would undermine public confidence in the justice system itself, sending a message that those in law enforcement are beyond accountability. Judge, I mean no disrespect, but I ask you to consider this on a human level. If someone spat in your face and your mouth, brandished a gun, and they were going to shoot you, said they were going to shoot you right now, would you believe disorderly conduct was a just charge? Would you consider it justice to let that person walk away with no record through accelerated rehabilitation? I have been denied justice again and again when it comes to the defendant, Brian Fahey. I have been victimized. My constitutional rights have been violated on camera for the world to see again and again. But today, this isn't about revenge. It's about integrity, fairness, and restoring faith in law. Justice must mean the same thing for everyone, regardless of their title or uniform. For these reasons, Judge, I respectfully ask the court deny the defendant's application for accelerated rehabilitation and set this matter for trial. Only a public trial where evidence is tested and truth is revealed can bring even a measure of justice, not just for me, but for every citizen who believes in accountability under the law. Thank you, Judge.
Thank you, Your Honor. I want to address a few things Mr. Reyes said. I completely agree with Mr. Reyes that equal protection under the law is of utmost concern. It is not only true equal protection, but even the appearance of equal protection under the law needs to exist. It does here. There is another individual involved who the state will ultimately offer AR to. The state would have offered it to Mr. Reyes. He's ineligible. His cases will be heard before Your Honor, as will the other individual on another day. I will say this. Mr. Reyes brings up the prior incidents. The state here is charged only with the conflicted matter that came out of the New London Judicial District that occurred on Mr. Fahey's property, not the other matters. The state feels that disorderly conduct is the appropriate charge. The state has researched The assault statute. The assault statute requires physical injury or pain. That, in the state's estimation, doesn't occur here. Additionally, there is, under the assault on public safety personnel, a specific reference to feces, urine, saliva being hurled or thrown at a public safety officer, and that's why that charge is different than the assault charge. Obviously, if the legislature chose to change that, they could. They have not to date. I need to charge on what's there. There's been much talk recently about threatening as a charge. I will start with the threshold matter that should former Sergeant Fahey have been charged with threatening and assault and disorderly conduct, he would likewise be eligible to apply to this court for accelerated rehabilitation. Those are not preclusive charges. I have done much research, case law. I've done much research with the jury instructions related to threatening, specifically threatening in the first degree, which would be threatening in the second degree by means of with the use of a firearm. I don't think it applies here for several reasons. First of all, in reviewing, we have asked, as the state's attorney's office, I've had an opportunity to review body-worn video from Groton Police Department when they responded to the scene. On scene, Mr. Reyes indicated and was provided, or was going to be provided, a link to Axon to upload the original unedited videos from his encounter with Mr. Fahey. He did not do that. Mr. Reyes spoke to my inspector about turning over a copy of the video. He said he would do that. He did not do that. To date, the state has not received, through counsel or from Mr. Reyes directly, a complete unedited version of the two videos that were out there. So the state is left to charge and review based on reports, based on body-worn camera, and based on edited videos that have occurred online. I will say that in reviewing transcripts and reviewing body-worn video of Mr. Reyes' encounter with at least one of the police officers on scene that night, he indicated he wasn't fearful of the defendant, that he would have engaged the defendant but for the firearm. In the state's estimation, the words, which could never have been conveyed that day from the 911 operator to Mr. Reyes, could not possibly have constituted an imminent threat to him at that point. They are, in the state's estimation, bluster. The reason I say that is because Mr. Fahey had a firearm, encountered the defendant, and never acted on those words. If there was a threat that day, it would have been having the firearm at his side, on his own property, by the way, which runs into a gray area of protecting. I know from the threats I've received online that my office has received and Mr. Fahey did indicate he had received threats, not from Mr. Reyes, okay, to be sure, and neither have I, but from people who have commented on Mr. Reyes' video, and thus the reality is one is entitled to defend oneself or one's family or others. There is justification when deadly threats have been raised against people. In watching the video, Mr. Fahey never, in the state's estimation, as they chest bumped out to the street, raised that firearm towards Mr. Reyes. He turned over the firearm when Groton arrived. And the reality of the situation is that Mr. Reyes himself that day, and in the state's estimation, if there was a threat, it was the firearm itself and not the words that were never heard by Mr. Reyes till some 6 weeks later. Mr. Reyes himself indicated on body-worn camera that in some ways he indicated he sort of saw the actions of Mr. Fahey as being understandable, except for the spitting. What bothered him was the spitting. And in the state's view, the appropriate charge for spitting in that situation is a charge of disorderly conduct, which the state upon reviewing the file, receiving the file, it took nearly a month to get the file here, and within a week or two, the state had the Groton Police Department prepare a warrant, which the state signed, and it was presented to a judge of the Superior Court. And Mr. Fahey, like any other citizen similarly situated, turned himself in on that warrant. And we stand here today before Your Honor on the AR application. But I wanted to make it clear why those other charges, because there's been much talk about those other charges. And in the state's estimation, those charges are inapplicable to the situation that occurred here. The state's ultimate goal, quite frankly, Judge, is, I know there's civil suits pending, I know there's ongoing litigation. The state's ultimate goal is for Mr. Fahey to stay away from Mr. Reyes, and for Mr. Reyes to stay away from Mr. Fahey. And that's the state's ultimate concern. The state does not want this to escalate any further than it has. But based on the actions that I must judge my charges on, and that is simply the actions at Mr. Fahey's house that day, not any previous actions, because I'm left with that simple conflicted incident and not the pattern of conduct. I felt that the disorderly charge was the appropriate charge, and that's what Mr. Fahey was charged with. Again, Judge, I think if we were to look at similarly situated defendants, and again, I will offer this, I can't offer it to Mr. Reyes because of his felony conviction. I can offer it to his cameraman. I intend to offer it on a charge to his cameraman if he wishes to take advantage of the program. I think if we were to sit downstairs, or Mr. Reyes was to sit downstairs on any given court date, similarly situated defendants would receive AR, and therefore the state has no objection to the granting of the program. I'll leave that to the court. I don't know if Attorney Ment will have some comments on that. Obviously, disorderly conduct is a 3-month misdemeanor, but whatever period Your Honor sets up to the maximum of the 2 years, that's up to Your Honor. I have no position on that.
Yes, thank you, Your Honor. I don't have much more to add. Mr. Fahey covered most of that. There is separate pending litigation between the parties. The prior acts are the subject of that. It's got nothing to do with today. With respect to this time period, we would ask for 3 months, given that that would be the maximum period for a Class C misdemeanor. And we would ask that the court grant the application for accelerated rehabilitation. I certainly understand Mr. Reyes' position, especially given that he was also arrested. But unfortunately, this program is not something that he's able to take advantage of. Thank you, Your Honor.
Anything further from anybody?
No, Your Honor.
Any objection to Mr. Reyes being further?
I don't, Your Honor.
Mr. Reyes, come forward.
Judge, I just wanted to clarify that the state's attorney did a great job defending Mr. Fahey here, but I did want to give all the video footage to the investigators. It doesn't show anything other than beforehand meetings with, so it's not something I'm trying to hide. I was advised by my attorney, Stephen Seeger, not to provide the video. I have no problem doing it, but I was advised by my attorney and I listened to my attorney, so it's not something that I'm trying to hide from the state or anybody. It doesn't, the entire interaction between myself and the defendant is recorded, unedited, other than what the state police say, that I edited out trespassing signs that don't exist, that my cameraman had a mask and a hood on, all types of lies, Judge, that are verifiably false. And again, I only brought up the prior incidents to show this is a pattern. I understand that's not what it's being charged with here today. And as far as me not understanding his behavior, Fahey went back inside, the defendant Fahey went back inside, he should have stayed inside. He came outside because he wanted to shoot me. That is evident here. And for you to grant an AR in this case, I understand that, you know, this happens all the time, but how many times are law enforcement officers who take an oath to uphold our constitutional rights, who take an oath to enforce law and order, are sitting before you, having spit in a citizen's face and mouth and drawn a firearm on them? That is evident here. And for you to grant an AR in this case, I understand that, you know, this happens all the time, but how many times are law enforcement officers who take an oath to uphold our constitutional rights, who take an oath to enforce law and order, are sitting before you, having spit in a citizen's face and mouth and drawn a firearm on them? This is not just an everyday citizen. This is a former law enforcement officer who should be held to a higher standard. And I don't believe that it is justice for him to be granted the AR. And I agree with the state. I want nothing. I don't want to ever see Ryan Fahey again after today, maybe at my trial. And again, the state argued a lot of semantics of, oh, he threatened you after the fact. That, you know what that did to my family, for my children, for my wife, to hear that this man was going to shoot me, to see the video of him spitting in my face, trying to provoke me. He said, the state's attorney said that I never threatened him. He told 911 that I threatened to kill him. He was setting this up to kill me, Judge. This might be a little disorderly conduct charge, but it's much graver than that. He said that he threatened to kill me. He made multiple false statements to law enforcement. The audio that when he spoke to law enforcement on the body camera footage, I don't have it. It's all been redacted. It's all been muted away. This is a cover-up. This is a conspiracy between the Groton Police Department. He talks about, oh, he had the gun on his hand, semantics. He's charging me with criminal trespassing for leaving in 2 seconds. Breach of the peace when it wasn't in public place. So I don't want to talk about elements of crimes and what fits and what doesn't, because the elements I'm charged with don't fit, and that will be before Your Honor on a motion to dismiss. But this is not justice, Judge, and thank you for allowing me to speak again. Again, I just want accountability and justice. Thank you.
I'm sorry, Judge, if I could just address one thing. I'm not here to defend Mr. Fahey. He has counsel. The reality is I was simply laying out for Your Honor why certain charges weren't charged when that's been put out there. As it relates to Mr. Reyes, his charges will be changed. He doesn't know this. He has counsel. It's not appropriate for me to speak to Mr. Reyes about that. But there will be a change in those charges as well based on my similar review as I did here. Mr. Reyes and I do agree on one thing. I wish Mr. Fahey had stayed in the house that day. I'm sure Mr. Fahey, to a certain extent, wishes he had stayed in the house that day. So, there is a limited incident that we're before Your Honor on, and I've laid out why we're here.
Court will take a brief recess to consider.
All rise. Court now stands in recess.
That I've heard so far. So I'm sitting in chambers considering everything that I've heard so far. If I was to take another hour or two to ensure to take my notes and my thoughts, put together something that would be a response that I'm aware of the time. The fact that I have made a decision to make a decision. Unlike other states, accelerated rehabilitation and it does not require an administrative bill. There are other states that require individuals to see something before they are granted permission. AR does not require that. But in order to apply for AR, there has to be an acknowledgement on some level that an actual crime has been alleged. I would indicate that in the time that I spent at the bench and currently the party judge here in the Judicial District, I oversee the disposition of murder cases, kidnapping cases, sexual assault cases, gang-related cases, racketeering cases. I've been in that for 4 years. I oversaw each of the Supreme Order docket and so detective order docket. Those dockets, various difficult dockets for judges. The allegations of all the people the request for protection of the courts, of the police. And without exaggeration, I can say that this is likely the most contentious matter that I had to deal with in the time that I've spent on that. I understand that folks, the parties feel very strongly about their positions. I wish that there was something that I could say that would de-escalate the situation. I don't know if that's possible. I certainly share Attorney Fahey's who indicated his position that de-escalation, I think, is what everybody needs, what would be best for everyone. but I'm not sure, as I said, that that's possible. And, Mr. Reyes, I appreciate your candor and your eloquence. I listened very carefully to your statement and your position. And I agree with you that spitting, being spat upon, the act of spitting on an individual is a vile and degrading. It's violent degrading, or intended to be degrading. I understand that outside of the assault on a public safety officer statute, that the spitting on individuals is not criminalized in Connecticut. I'm fairly certain in other states that spitting on another individual, not a public safety officer, a public safety officer is a very, very, very broad category. Not just police officers, but also healthcare workers, BCS workers. I'm not going to get into the policy considerations that bodily fluids in that statute, I don't think is intended to undercut how degrading an act is to spit on another individual. I think that we all understand that. We all should understand. And hopefully, Mr. Fahey, the defendant, I'm told that he regrets what happened that day. It does not undercut as something vile and degrading. Yes, I have sat for many years and many times in DA and have been presented many applications on accelerated rehabilitation. And as a jurist, I understand that it is within my discretion to grant or not grant AR, that the legislature, the appellate court, and then the Supreme Court have afforded wide discretion to the court in granting accelerated rehabilitation. And I have been a criminal defense attorney. I have worked with other judges. I know that every judge differs on cases that they think are too serious to grant AR to the legislature. The appellate court and the Supreme Court, they typically defer to the court and those decisions. And while I'm not intending to claim my position among the more lenient of those judges, I will note that, and I will accept, but I will accept that I am a judge inclined to grant accelerated rehabilitation in many, or not most of the cases presented with those applications. Because in order to be eligible for AR, you have to have no record, no record. The charges cannot be precluded by the statute. There are charges for which you cannot get AR. And I've often heard it argued that the possibility of the individual ending up with no record seems unjust, that diversionary programs just a slap on the wrist. And my position is that if one acknowledges that an actual crime has been alleged, an individual is not asked to admit guilt. And the goal is to have no record of that alleged actual crime on their record. That there would have to be something that an individual would have to do to confirm that, as opposed to it just being granted in the ordinary course, as if it were not ultimately serious matter. As a judge, I have tried throughout my career to listen very carefully to everything that's been said. Oftentimes I have found that individuals want to be heard And having been a defense attorney, I've seen judges not pay attention. But I also understand that hearing someone's position, acknowledging that the validity of that position, agreeing with some parts of those positions, does not always mean that I, the court, is going to do what that person asked in court. So my job, if my decision differs from what I've been asked to do, is to explain my position, while letting everybody know or feel that I hear it. I heard it. The background of the case, the conflict in the case, creates a serious matter for the court to address. Any decision the court makes is probably not going to de-escalate the situation. On discharge, even taking into account that day in, on a day-to-day basis, what would this court do? Any honest answer from my perspective, the right thing is great. The request was for 90 days. I think that's a 90-day program with the background of this case, the contentiousness of the case. I think that trivialized what occurred. And I think that a lengthier period of AR would be appropriate. My understanding is that there are other matters pending in other aspects of the court. There's a civil matter that will probably go on for quite some time. I agree with Attorney Fahey that the parties should stay away from each other and certainly do everything they can not be, and the court will do what it can to make sure that they are not in the same place at the same time. But through the AR period, I know that Mr. Reyes would then have some protection from Mr. Fahey in terms of an order that would require Mr. Fahey to initiate no contact with him. And that may allow some breathing space in order for the civil matters to resolve without the possibility of contentiousness that would be inappropriate and would result in a violation of accelerated deportation. And so I would find that the charges against Mr. Fahey are not so serious as to include the grant of JR. And I will grant accelerated deportation for a period of 18 months. That is 6 months longer than the average grant of AR. Is to incur no arrest for which qualifying probable cause. Is to initiate no contact. And given the nature of the disorderly conduct, the allegations, I want to engage any counseling and treatment directed by adult stage. If there's some anger management or counseling that would be helpful to Mr. Fahey going forward. The law is clear that police officers are held to a higher standard than other individuals with regard to their interactions with others. I realize the complicated context of everything, but I agree with Mr. Reyes. I think what's stated in some of these cases is discussed. For 18 months, April 9th of 2027. And the matter is returned to court. They are to be terminated, and the questions of guilt not required by AR would then be settled by a jury of Mr. Davis' peers. So there's nothing further to the party.
Nothing, Your Honor.
We are adjourned.
All rise. Court now stands.
Alright, fellow patriots, the courtroom footage is courtesy of Justice Served TV. I'll leave a link to their channel in the description below the like button so you can check out their exclusive after-court interview with yours truly. So to summarize the proceedings, the former disgraced police sergeant Brian Fahey and the state were asking for a 3-month probationary period, with the case being dismissed after the completion. The judge ended up granting the diversion program, but extended the probationary period to 18 months and recommended counseling such as anger management or mental health. Now, do I agree with the judge's decision granting the accelerated rehabilitation? Obviously, I do not. I just want to make sure that the blame goes to the right person. State's attorney John Fahey had a constitutional obligation to charge Brian Fahey with felony threatening and reckless endangerment in addition to the disorderly conduct charge. He failed to honor his oath. I think his reasoning on why he only charged disorderly conduct was disingenuous at best. It's unfortunate that Brian Fahey won't be held accountable in a criminal court with a public trial, but at least we the people not only exposed the deranged psycho and got him to retire, we also exposed a biased state's attorney who doesn't honor his oath, and the rotten police department who conspired with Fahey to violate not only my constitutional rights but my cameraman's as well. Fortunately, Fahey has already been denied qualified immunity in my first federal lawsuit against him, and as soon as my charges are dismissed, and I am confident they will be, I will be filing another one. I promise each and every one of you that I will do everything in my power to make sure Fahey is held accountable in a civil court of law. Make sure you're subscribed. We the people are almost 1 million strong. I truly appreciate all of your support. We take on tyranny together. I couldn't do this without you. United, we are strong. Stay tuned and make sure to have notifications turned on so you don't miss any upcoming videos. Let me know your thoughts on this one in the comment section below. As always, stay safe. God bless. I'll see you in the next one. Long Island Audit. Peace.